Hi, Stefano Molea here, San Diego criminal defense lawyer and partner at the law office of David P. Shapiro, where we help good people regain control of their future when charged with a crime. I want to talk about a scenario in which a lot of people find themselves violating the law, and it's not always intentional. It's just a lot happens all at once, and things are missed. So I just want to discuss a scenario that can get somebody tripped up that might be avoided if you're sort of aware and if you have reason to pay attention. So let's say that there's a domestic violence dispute. The police come and you get arrested. Sometimes the police will ask the complaining witness or the alleged victim, same thing, interchangeable, whether or not they want an emergency protective order. And that's usually about 10 days, but essentially if they want the emergency protective order, law enforcement will contact the on-duty judge, ask for the emergency protective order, and it will essentially be in effect, like I said, for about 10 days. But obviously the end date will be on that emergency protective order. Now that emergency protective order, EPO for short, will essentially outline all the things that the person who was arrested cannot do. Obviously it's going to be don't contact directly or indirectly in any way the person who's protected, who's going to obviously be the alleged victim or the complaining witness. And sometimes they'll say don't come within 100 yards, etc., etc., etc. It's an order to not do certain things. Now police will serve this to the person a lot of times when they are in the back of the patrol vehicle in handcuffs. And what they're supposed to do typically is either read it to them or provide them a copy so that they can fully read it and make, absorb the information in the emergency protective order. And a lot of times, we'll see that law enforcement will read the terms of the emergency protective order, essentially read it verbatim, explain exactly what it means, explain that this means they can't contact them, and then they get booked into custody. And guess what they do when they get booked into custody? One of the first phone calls they make is to the person who's protected. Well, guess what? That's a violation of a protective order, and assuming that it was lawfully issued and lawfully served, you were told about it, and yet you're still making a phone call, and that's a problem. Because now you have arguably violated Penal Code Section 166, which essentially outlines a variation of various scenarios related to violating a lawfully issued court order. So that's a misdemeanor, right? So sometimes you could be charged with a domestic violence incident, and then you could also be charged with violating a court order for calling the person that was listed as the protected party in the EPO. Other times, what's sort of really crazy about it all is that someone will, law enforcement may issue this EPO or serve it, the person will go into jail, and then they will make a phone call. And that phone call will be to the protected party, which is obviously a violation of the EPO. And then the prosecution may think, well, you know what? We don't actually think that there's enough to prove that the domestic violence incident happened beyond a reasonable doubt, but we do think that there's enough evidence to demonstrate that the emergency protective order was in fact violated beyond a reasonable doubt. So you may be in the situation where if you would have just paused and absorbed what the cop was telling you in a very stressful situation, you may have avoided, obviously being charged with violation of an EPO. So just wanted to bring this to the forefront of a scenario that may present itself, hopefully not. But if you have any questions or comments, leave them in the comments or give us a call. Stefano Molea here, partner at the law office of David P. Shapiro, 619-295-3555.